welcome to This Explainer. Today we're diving deep to decode the absolute true foundation of property law. We're going to pull back the curtain on this invisible, intricate legal web of ownership. Honestly, you should probably forget what you think you know about real estate, because the physical stuff you see on the surface, it's really just a tiny fraction of the actual reality.
So here's our roadmap for today. We're going to systematically break this all down into 6 clear steps. Property is not the thing, legal title versus equity, deeds, recording and chain of title, title defects and clouds, and finally, identify the legal interest. We've all heard people scream, "They stole my house," or "The bank owns nothing," or "The deed proves everything," right? We hear these phrases all the time. But look, this is the great illusion of property disputes. Statements like that are completely driven by raw emotion and suspicion, not actual legal analysis. The hard legal reality is that property analysis never, ever begins with emotion. It begins by taking a breath and calmly identifying the specific legal interests at play.
Let's jump straight into step 1. Property is not the thing. While a house is obviously a tangible, physical object made of land, bricks, and wood, the legal reality is entirely different. Legally speaking, property is actually about the recognized relationship between people, rights, interests, duties, and that physical object.
Real property is legally defined as the land, improvements, fixtures, and, crucially, the legally recognized rights and interests connected to them. The law honestly doesn't just care about who physically lives on the land. It asks what legally recognized interest exists here, who actually holds it, and what exactly limits it. It's kind of like a multi-layered cake. These rights are broken down into fascinating layers. You have your improvements, which are the human-made additions like houses or fences. Then you have fixtures. Think built-in cabinets that start off as personal property but legally become fused to the real estate. Then it gets wild down below with mineral rights. You could literally own the backyard where you barbecue, but a totally different company could legally own the rights to the coal 50 feet right below your grill. And let's not forget possessory interests, where a tenant has a rock-solid legal right to possess and occupy a property without actually owning a piece of it. Which brings us to Section 2, legal title versus equity. Legal title is the formal ownership recognized by law and the public record. This is exactly what the courts, your lenders, and the tax offices are going to look at first. Equitable interest, on the flip side, is all about beneficial or fairness-based rights. A perfect everyday example of this is a trust. A trustee might hold the formal legal title and have all the management authority, while the beneficiary holds the equitable beneficial interest. They're related, sure, but they are completely distinct legal concepts.
Now, we absolutely have to bust a major myth right here. Equity is incredibly powerful, but it is not a shortcut around the law. Equity doesn't mean, well, I feel like it's mine, therefore the judge has to agree and just do what feels fair. That's not how it works. Equitable rights still have to be proven and enforced through strict lawful procedure. A beneficial interest simply does not automatically wipe out legal title just because someone really wants it to.
Let's move on to Section 3, deeds and transferring the interest.
Not all deeds are created equal. They do entirely different things. A warranty deed actually includes legally binding promises, warranties about the title. But a quitclaim deed, that only conveys whatever present interest the grantor happens to have right now, with absolutely zero guarantees. Think about it. I could sign a perfectly legal quitclaim deed right this second, giving you the Brooklyn Bridge. But since I obviously don't own it, you get absolutely nothing. We also have special warranty deeds, which only offer limited guarantees for the grantor's specific time of ownership, and things like trustee or sheriff deeds used in very specific trust or court sales. The actual type of document completely changes the legal reality of what's happening.
Because a deed is just a legal instrument, you've got to rigorously stress test it. First up, you have to verify the grantor's actual legal authority to convey the interest and precisely identify the grantee. You have to scrutinize the conveyance language itself. You absolutely must check the legal description. And hey, remember this, a street address is just a location for the mailman. It is not a legal description. Finally, you double-check the execution dates, signatures, and mental capacity of the signers. Bottom line, a deed can never magically create more rights than the grantor actually had the legal authority to give away.
Okay, Section 4, recording and the chain of title.
So, recording a document down at the county land records is what actually establishes priority. It creates this vital concept called constructive notice. Basically, this is the legal principle that treats all later parties as if they have full notice of properly recorded instruments, regardless of whether they ever personally bothered to read them. This is absolutely critical. It's what protects subsequent purchasers and lenders by establishing a permanent public chain of documents.
But please pay really close attention to this next point. Recording gives public notice, sure, but recording does not equal legal truth. A recorded document might still be totally defective. It could be void, unauthorized, or completely forged. The recorder's office generally isn't sitting there playing judge and jury to adjudicate the validity of every piece of paper. Recording it just puts it in the public file. That's it.
And because a recorded document isn't inherently perfect just because it's stamped, we have to actively trace the chain of title. This is basically the historical story of the property's ownership. It's like detective work. You start with the current record owner, you locate the most recent deed, identify the grantor and grantee, and then you just systematically trace it backward through the prior deeds. You're literally tracking the story backwards, step by step, to see if every single legal link actually connects.
So what happens when that legal story hits a massive plot hole? Section 5, Title Defects and Clouds.
When that chain of title breaks, it creates what's known as a cloud on title. Now, that sounds kind of poetic, right? But it's actually a claim, encumbrance, or defect that heavily impacts ownership and will absolutely send future purchasers or lenders running for the hills. A cloud on title isn't just a catchy legal phrase, it's a very tangible, expensive legal problem. And again, you can't solve it by getting angry. It has to be corrected through proper legal channels. Things like filing a quiet title action, executing a corrective deed, or getting a formal lien release.
These common title defects can literally derail everything. You might stumble over unreleased liens, like a 20-year-old mortgage or a forgotten HOA lien that was just never officially discharged. You could uncover incorrect legal descriptions, missing document assignments, or straight-up forged signatures. A really massive one we see all the time is a probate gap, where someone passed away and their property didn't properly go through the probate process, leaving this giant hole in the estate's legal authority. Any one of these gaps or competing deeds can completely paralyze a property transfer.
Which finally brings us to Section 6, Identify the legal interest. Here is the absolute golden rule for you today. Before you can ever argue about the remedy, you must understand the underlying property interest. Whether you are dealing with a messy foreclosure, a complex trust administration, or basic estate management, you literally cannot skip straight to the remedy without identifying the underlying rights first. Every single property dispute, without exception, begins by identifying the interest. I want you to consider this your ultimate diagnostic toolkit. Whenever you are faced with a property issue, I need you to replace that initial emotional reaction with a structured legal analysis. Start asking yourself the hard questions. Who exactly holds the record title? Who actually has physical possession of the property right now? Who holds a security interest or has lien priority? And precisely what recorded instrument created that interest in the first place? And it all boils down to the single most important question you can ever ask in real estate law. What exact property interest exists? Honestly, before you spend a second arguing about taxes, foreclosures, or title rights, you have to answer this. Because this one question, it's the gateway to understanding and resolving literally every single property dispute you will ever encounter. Thanks so much for joining me for this explainer, and I really hope it completely changes the way you look at property from here on out.